versus Huffman. Counsel, are you ready to proceed?
Good afternoon, Your Honors, and may it please the Court. Jenya Godina on behalf of Petitioner Mr. Berryman. I've reserved 4 minutes for rebuttal. The Supreme Court held in Barker and in Strunk that the severe remedy of dismissal of the indictment is the only possible remedy for a violation of the speedy trial right. The state court's disregard for that clearly established principle of federal law, among other errors, requires habeas relief in this case. The petitioner here suffered 1,233 days of delay before he was brought to trial. Delays largely attributable to the state's negligence and its mishandling of his case. That was so notwithstanding that he dutifully asserted his right to a speedy trial at every turn. And in the meantime, a witness critical to his defense died. That means that every single one of the Barker factors weighed in his favor. But nevertheless, the state court dismissed just one count of his indictment, allowed the other count to proceed to trial, and without the benefit of his witness, petitioner was found guilty and sentenced to life without the possibility of parole. The state court's decision contravened clearly established federal law in 2 respects. First, despite having found a speedy trial violation within the confines of this very prosecution, the state court opted to carve out an exception from the Supreme Court's rule as to remedy. It created a new jurisprudence specific to multi-count indictments, under which it opted to analyze the Barker factors count by count, and so ordered only partial dismissal instead of dismissal of the indictment. That was both contrary to and an unreasonable application of clearly established federal law. Second, even setting that aside and assuming for the moment that the Barker analysis can be conducted count by count, the state court's ultimate determination as to the weighing of the Barker factors on the remaining felon in possession count was objectively unreasonable. Just as the death of the witness, Marshall Edge, prejudiced the petitioner as to count 1, the shooting into a dwelling count, it likewise prejudiced him on his closely related defense to count 2, the felon in possession count. Count 2, therefore, should have also been dismissed. I'll turn first to the issue of the count-by-count application of Barker. So instead of faithfully applying the Supreme Court's clearly established rule that dismissal of the indictment is the only remedy for a speedy trial violation, the state court here carved out an unauthorized and unsupported exclusion. It did so over a dissent by Judge McCarthy that pointed out the contrary clearly established law. And in doing so, it created what the leading criminal law treatise, the Lefebvre treatise, called an unusual and novel remedial approach. We've never seen anything like it. Cabining the Supreme Court's rule in that manner was contrary to the Supreme Court's clearly established law because multi-count indictments already fall within the rule that the Supreme Court established.
Counsel, are there any cases that you can point to by the Supreme Court that address multi-count indictments where one count is subject to a speedy trial violation and the other isn't?
Yes, all of the cases that we rely on, Barker, Strunk, all of those cases, the rule that they articulated already encompasses multi-count indictments. And we know that from Strunk itself, we know that from Barker itself, and it's also confirmed by the numerous other cases of the Supreme Court when it's describing this rule, but sometimes in multi-count indictment cases.
Didn't both of those cases involve single-count indictments?
The particular indictment that was before the court in Barker and in Strunk was single count, but it's still possible to discern from the substance of the opinions that the rule they established was meant to encompass all kinds of indictments. So I'm happy to expand upon what in Strunk and what in Barker illustrates that.
Can you point me to any case that extended Strunk or Barker to a multi-count indictment by the Supreme Court?
Well, every case that we're aware of where there has been a speedy trial violation involving a multi-count indictment, there's been dismissal of the entire indictment. The state here has not pointed to any appellate case, any case at all that has endorsed a piecemeal remedy. So, for example, in Doggett, there was a multi-count indictment, and the Supreme Court order dismissal of the entire indictment there.
Isn't it the petitioner's burden here on habeas to identify the clearly established law rather than the state's?
Yes, and it's this court's obligation to first ascertain the clearly established law before then deferring to the state court's application of it. So here, we can discern on the face of Strunk that the rule that it articulated already encompassed multi-count indictments. So nobody thinks that even though the rule is phrased as the only possible remedy is dismissal of the indictment, but in a case that was charged by information rather than by indictment, does the rule still apply? Of course it does. And that's because the Supreme Court's rule was not cabined to the particular kind of charging instrument that was before the court. It's much more broadly than that. We know that from Strunk's reasoning. So the unit for the remedy that Strunk selected was the indictment, and that was no accident. It was the rationale for that was the Strunk court's understanding that this is a right that sweeps more broadly than what the remedy the government was pressing that case would have had. It is a right that attaches once a defendant is accused, and then it attaches to the entire prosecution. And it protects the right of that defendant and also the public to have that prosecution speedily disposed of. And so it can be violated just one time in one way and at one level, at the level of the entire prosecution. That's why there's only one possible remedy, and why that remedy has to be at the level of the entire prosecution. That is why in Strunk, the court rejected the government's effort in that case to carve out just one segment of the prosecution, the one particular portion that caused particular private harm to the defendant, the period between the indictment and the arraignment, which interfered with the defendant's ability to serve that portion of his sentence concurrently. The government had wanted to tailor the remedy to address just that one portion of the prosecution. And the court firmly rejected that. So we don't tailor remedies in that way for the speedy trial right, because it can be violated only at one level, at the prosecution level. That's why it rejected the government's proposed remedy and announced only one possible remedy. So when it announced that rule, it necessarily had to apply to all kinds of charging instruments, and it already encompassed multi-count indictments. We also know from Barker that Barker had multi-count indictments in mind when it set forth its rule. We know that from footnote 36.
I'm going to stop you right there and back up. How do we know? Where does it say that it contemplated a multi-count indictment?
Well, Strunk clearly states that the right protects both public and private interests, and that is part of the reason why carving up the remedy the way the government wanted in that case would not suffice. So in articulating the remedy, it shed light on the nature of the right, and it showed that the right is a right that attaches and in substance protects, and thus can only be violated by a violation that strikes at the heart of the prosecution as a whole, not some particular part of it, whether it's one particular segment of delay as the government was pressing that case, or the arbitrary unit of one particular count as the state presses here and as the state courts endorsed.
I'm still having a little trouble understanding what the clearly established federal law was. Would you agree that Strunk was not a materially indistinguishable? No. Would you agree that Strunk in this case are not materially indistinguishable based on the facts?
I don't agree. I believe they're materially indistinguishable because the difference between a single count indictment, as was present in Strunk, or a multi-count indictment here was not material to the court's holding, because the court, the holding applies whenever it's exactly the same facts or essentially the same facts as was in the contemplation of the Supreme Court when it laid down its rule, and that's the world that we're in here. So we know that based on what I've highlighted about Strunk's rationale. It's even clearer in Barker, because in footnote 36 of Barker, the court cites and it explicitly holds up as an exemplar of how the speedy trial right analysis should be conducted. This 1968 case from the Southern District of New York, United States versus Mann, that case was a multi-count indictment case. I can give you the pin site for it. It's 291 F sub 268. That case involved a multi-count indictment. It said so right in the first line of the opinion, 5-count indictment. And yet, it analyzed prejudice holistically, not count by count. It did it looked at each count in order to answer the ultimate question, was the
case that was cited in footnote 36, was that a multi-count indictment, or was that also?
Yes, that,
United States versus Mann?
correct. So that was a 5-count indictment case that the Supreme Court said modeled exactly the way that the Supreme Court the speedy trial analysis should be done. And the way that it did the analysis was exactly what we're urging here. What the Supreme Court has already established is the law. It's you can look at each count and assess the prejudice, but that has to be in service of answering the broader question: was there prejudice in this prosecution as a whole? Not was there prejudice as to one count or the other count, because that's the substance of what the right protects. And man, it's very interesting because the counts actually could have, you could imagine witnesses that would have prejudiced the defendant as to one count but not the other, as the state claims is the case here. I'll address in part 2 of my argument why that's not correct, but even assuming for the moment. In Mann, that was the case, and the court identified particular trial prejudice as to several of the counts. There were charges relating to fraud related to 3 companies, identified the prejudice as to 2 of the companies and not the third, and that didn't matter because the purpose of the analysis was in service of deciding whether overall there was prejudice to the defense within the prosecution. It's not a count by count.
What case best supports your contention that the state court's actions were an unreasonable application of clearly established law?
So all of the cases I've discussed so far, as well as the other number cases in the briefs, all show why this was contrary to the Supreme Court's rule, but it's also an unreasonable application because this is like what the Supreme Court described in Yarborough. I'd say that's our best case describing the kind of principle at issue here. Even if you don't think that the rule was already, multi-count indictments were already encompassed by the Supreme Court's rule, at minimum, this is a principle of the kind the Supreme Court described in Yarborough that is fundamental enough that when new factual permutations arise, it's obvious that it must be applied.
Doesn't that argument really ask us to get to the merits, which is a question to be determined on direct appeal, whereas here we're more cabined in our review?
So it's this court's independent obligation to first ascertain what the clearly established law here. That is here. And so this court can look to Barker and Strunk and ascertain what's the best interpretation, what's the correct interpretation of those cases before deferring to any application by the state court. But even if you think you're beyond that and you're in this Yarborough world of deciding whether the principle applies to new factual permutation, it's the carve-out that the state courts invented here is clearly unreasonable because of the clearly established rule that I've described that already encompassed multi-count indictments because of the nature of the right, which is simply inconsistent with carving out this multi-count indictment jurisprudence.
I'm just trying to understand here. You said all the cases a couple of times. Can you point me to specific cases other than Barker and Strunk?
Absolutely. So every time the Supreme Court has described its rule, it's also consistent with the understanding that it already encompasses multi-count indictments. So one case is a pre-Barker case, the Marion case. That was a 19-count indictment case where the court framed its question as whether dismissal of the indictment was going to be required.
But in Marion, didn't all of the conduct that supported all 19 counts occur at the same time? And didn't the Supreme Court reverse the district court's dismissal of the indictment?
It reversed because of the nature of when the delay took place. In that case, took it outside the purview of the speedy trial right, but that doesn't change the point that the court framed the speedy trial inquiry as being whether the entire, or I'm sorry, I didn't say entire, but whether the dismissal of the indictment was required, and it said that in a multi-count indictment case, it did not contemplate that some portion of the indictment, some portion of those 19 counts could be dismissed. And that's far from the only case. We also cite Loud Hawk. That was a multi-count indictment case. There were separate firearm and dynamite counts charged there, and it also contemplated the severe remedy of dismissing the indictment is what would have applied there had there been a speedy trial right. We have Doggett. That was an actual multi-count indictment case where dismissal of the indictment was ordered by the court. We have McDonald, that involved 3 separate counts of murder. It cited Strunk for the proposition that dismissal of the indictment, not dismissal of some portion of the indictment, was going to be required in that case. We also have cases that didn't themselves involve multi-count indictments, but describe the rule in a way that makes clear that a speedy trial violation is case dispositive, which necessarily means the entire indictment has to be dismissed. So Berryman and Hollywood Motor are the cases we cite there. They reference determination of the prosecution and being dispositive of the entire case when there's a speedy trial violation. So here there was a speedy trial violation that was adjudicated, and it was never challenged by the state. We know that there was a speedy trial violation within the context of this prosecution. The Supreme Court has made very clear what the only remedy is: dismissal of the indictment, a rule that applies to multi-count indictments just as it does to single-count indictments. I see my time is near its expiration. I'd be happy to address part 2, but I could address it on rebuttal if that's preferred. Thank you. That concludes my remarks.
May it please the court, Anthony Shults on behalf of the state. The state court's decision in this case was not contrary to or an unreasonable application of any clearly established law by the Supreme Court. This court should affirm the denial of habeas relief for 3 main reasons. First, petitioner cannot claim that the Supreme Court has even addressed whether a dismissal remedy applies to counts of a multi-count indictment that do not implicate a speedy trial violation. They couldn't do so in their brief. They couldn't do so in argument today from questioning from Judge Ramirez.
How do you respond to the argument that footnote 36 in Barker cites to United States versus Mann as a way to deal with these types of cases? And according to counsel on the other side, that was a 5-count indictment.
Sure. A few responses to that. First, this is a new argument, so I apologize for not having read the case completely, but in just now I was able to look at it. And it was a case where there was a 9.5-year delay, where the court said it was shocking on its face and the weighty presumption of prejudice where the delay is as long as it is in this case. So it kind of fits into the dogged category, I would say, where there's a presumed presumption of prejudice, not a case where the court had to go count by count to determine whether prejudice applied to different contexts. And of course, it's also a district court case. It's not clearly established law of the Supreme Court. And of course, we're not arguing that it's always necessary to go count by count to make a prejudice determination. We're simply saying there's no Supreme Court holding that says you cannot do so in unique cases like this one, where at the very least the only possible prejudice that the petitioner could have alleged was prejudice to his defense. In the normal case, there is prejudice from potentially anxiety and concern of the accused, pretrial delay. None of those types of prejudice applied in this case. So considering that, as well as the fact that the different crimes with which the petitioner was charged had different elements, it was proper under the facts of this case to assess count by count. And there's nothing in Barker, there's nothing in Strung's to suggest that you can't do that. In fact, as my friend just said, the remedy of dismissal is required to address a speedy trial violation. Well, the court here found a speedy trial violation and addressed that by completely dismissing the count, the shooting into a dwelling count.
Is there anything in Barker or Strunk that can be read to apply only to those cases that are single count?
Well, I think you need to read the cases in context, of course. And Barker said you need to apply 4 factors to determine whether the right has been violated. When you apply those factors in this case, the state court determined there is prejudice as to one count and not another. So it applied the remedy of dismissal to the count where there was a violation, and it chose not to apply a remedy to a count where there was no violation. The entire concept of a remedy in the law is to address a violation, and that is exactly what the courts did in this case. What petitioner is really asking for is an extension of Barker and Strunk to say that the extreme remedy of dismissal applies not just to speedy trial count violations, but where there is no violation as well. And that is not clearly established by any holding, Barker, Strunk, or any other cases that counsel mentioned. In fact, I think she referenced cases like Berryman or Marion, as Judge Ramirez, I believe, pointed out, neither one of those cases were actually speedy trial cases. In Marion, it was about pre-indictment delay, so the speedy trial right was, quote, wholly irrelevant. I do not know how you can have a clearly established holding of the Supreme Court about the proper remedy for speedy trial violations in a case where the speedy trial right was wholly irrelevant. Berryman also was not a speedy trial clause case. It said that speedy trial rights do not apply to sentencing. So again, you cannot have a clear holding of the Supreme Court in a case where the speedy trial right did not even apply. And just to go back to the beginning, Barker adopted a functional, flexible balancing test the courts must apply based on the context of the case to determine whether the speedy trial right has been violated. And the only possible remedy for a violation, we agree completely, is dismissal. And that is exactly what the state courts did here. They dismissed completely, with no possibility of retrial, the only count for which there actually was an adjudicated speedy trial violation. They then refused to extend the remedy to a situation where there was no violation. That is completely consistent with Barker and Strunk and the law of remedies generally. Barker itself expressly tied the remedy of dismissal to situations where, quote, the right has been deprived. Mr. Berryman's right was not deprived on the felon in possession count. Therefore, it would be anomalous and has no basis in any clear Supreme Court holding to say you must remedy a non-violation by dismissing the count. It was not issue in Barker, it was not issue in Strunk, and the other cases that my friend mentions also did not deal with the specific situation that we have in this case, and that is fatal to a petitioner under AEDPA. As I mentioned, Strunk as well also was a single count indictment case. It made clear, absolutely clear, that it would be improper to order a remedy other than dismissal, again, to address an actual violation. What the lower court did in that case was say, you know, we don't think the violation is that serious and the crime at issue was bad enough. Let's just reduce the defendant's sentence by the amount of time which there was delay in that case. And the Supreme Court said, no, you can't do that. We have established that the remedy for a violation is dismissal, period. When there is a violation, you must dismiss to address that violation.
Were there two counts or only one in that case?
There was only one in that case, Your Honor. So,
well, how do you handle the difference?
well, first I would observe that it's petitioner's obligation to find a clearly all fours case to get relief under AEDPA. But I'd also say that Barker and Strunk say the same thing. You apply the factors that Barker set out to determine whether or not the right has been violated under the circumstances of the case.
But both of those cases had only one indictment.
Correct, exactly. So when they said the only possible remedy is dismissal, they were addressing a single count indictment context. There was no reason for them to consider what would happen in a multi-count case where some counts might have implicated a violation and some did not. There was no reason for the court to do that.
The case law does appear to put the burden on the petitioner here to identify the clearly established law, but are you aware of any case, any Supreme Court authority addressing multi-count indictments where there's a speedy trial violation as to some, but not all?
No, Your Honor. The only cases that petitioner has identified and that the lower courts were able to find and that we have been able to find either have single count indictments like Barker or Strunk or reject a speedy trial claim completely and deny it across the board so they wouldn't have to determine whether there was a violation as to some but not others, or cases like Berryman and others where the speedy trial right did not apply. And again, we're not arguing that it is always the case that you have to go count by count and maybe divide a remedy. That's not what we're saying. We're saying that this is a particularly unique case for multiple reasons, including because the defendant in this case had previous life sentences and was on parole that he absconded from. So when he was arrested on the charges in this case, he was committed to the custody of the Mississippi authorities and was in prison anyway, and would have remained in prison anyway, regardless of how this case turned out. So there's no reason to consider factors like anxiety and concern of the accused or pretrial detention that normal speedy trial cases involve as a factor of prejudice. So this is a unique case, as all the courts below said. And when you have a unique case and there's no Supreme Court holding on point, you simply cannot get relief under AEDPA. In fact, we noticed that is the case because before they backtracked completely in their reply brief, My friend argued that adopting his rule requires, quote, extending Barker and its progeny to a, quote, new context. And that is exactly the view that the Supreme Court has rejected time and again. The Supreme Court in White versus Woodhull said, it is improper to treat failure to extend its precedent as an error warranting relief. If a court must extend a rationale before it can apply to the facts at hand, by definition, that rationale was not clearly established at the time of the relevant state court decision. So when they said that we need to extend the rule of Barker and Strunk to a new context, they basically gave the game away here. Now, it is of course true that you don't need an exact factual facsimile to apply a rule from a Supreme Court. We're not arguing that, but you need at least two things. One, you need a clear rule. The Supreme Court has said time and again, including in Harrington versus Richter, that it is not an unreasonable application of clearly established federal law for a state court to decline to apply a specific legal rule that has not been squarely established by this court. And as petitioner has not been able to point to, there is no clearly established rule requiring dismissal of counts where there is no violation at all. Now, the difference between applying a rule, which is okay, and extending it is not always clear. But in this case, we know that there's an extension involved because the petitioner told you there is. They said that they want to extend the rule to a new context. And in any event, the application wouldn't be proper anyway because the necessity to apply a rule must be, quote, beyond doubt. And that is the Yarborough case of the Supreme Court. And there's clearly, we would submit, more than a doubt about whether their rule should apply in this context. In fact, so far, at least 10 judges at the state court and federal court level have rejected the rule that petitioner is advocating. So at the very, very least, there is the possibility for fair-minded disagreement, and that, again, precludes habeas relief.
Doesn't our case law provide for habeas relief if the state court unreasonably refuses to extend the principle to a new context where it should apply?
Yes, Your Honor, there are cases that use that language, which comes from I believe, a 2004 Supreme Court decision. But the later case in White versus Woodhull said that that is actually not the law. And I know petitioner has pointed to a few cases where that language is included, perhaps in boilerplate standard review. But in no case that they identify has the court actually applied that standard to grant relief. I believe they point to 5 cases in recent years, only one of which actually postdated this court's en banc decision in Lucio, which we cite in our brief, which said that the Supreme Court squarely and expressly repudiated the unreasonable failure to extend reading of AEDPA. And again, none of those cases that they cite actually apply that standard. In fact, if they ever mentioned it again in the opinion after the boilerplate recitation, it was to fault the petitioner for trying to extend Supreme Court case law, which you simply cannot do in habeas. So we submit, contrary to cannot apply because there is no clear holding of the Supreme Court. Unreasonable application cannot apply because they're trying to extend a rule that doesn't exist into a new context. And at the very least, as I mentioned, there is a possibility for fair-minded disagreement about whether that should happen, which means there cannot be habeas relief. And just to support the fact that we're not dealing with the lack of an identical factual pattern, think of the implications of saying that you need to dismiss, regardless of the results of the Barker analysis, every count of a multi-count indictment. As this court knows, prosecutors have discretion with how they charge cases. Often they charge multiple defendants in single indictments. Does petitioner's rule mean that if there is a single speedy trial violation as to one count of a multi-count indictment with multiple defendants, that the entire indictment must be dismissed as to every single defendant, even if, for example, not every count applied to every defendant, or the prejudice alleged only applies to some counts but not others, or in fact some of the defendants maybe didn't want a speedy trial so they didn't assert their rights? That is a difficult question that the Supreme Court has not addressed, and it just shows that there's no clearly established law on this issue. Similarly, prosecutors can bring multi-count indictments, or they can bring separate single-count indictments. If all a prosecutor needs to do to avoid my friend's proposed rule is to bring separate single-count indictments, then that is no rule at all. And I presume what my friend will say is, no, you can't do that. You'll have to create a rule where it's like you dismiss the indictment and any other charge relevant to the indictment. But that's not in Barker, that is not in Strunk, that has not been clearly established by this court. In fact, this exact case presents that scenario. The defendant was charged in 2 separate indictments. One was for the shooting into a dwelling and felon in possession we're dealing with here. And separately, 2 drug charges were also indicted from the same course of events. Is my friend arguing that that indictment also must be dismissed? Again, there's no clear law on this from the Supreme Court, and we cannot make it here in habeas. As I alluded to before, the count-by-count approach that the state applied is entirely consistent with Barker. It applies the remedy of absolute dismissal to any count for which the Barker factors suggest that there is a speedy trial violation, which is what Barker Instruct says you have to do. And it properly denies a remedy where there is no violation. Again, a remedy is supposed to follow the right. Where the right is not violated, there should be no remedy. And petitioner, in this case, faults the trial court for proceeding to analyze the second count for felon in possession after it determined that there was a speedy trial violation as to the shooting into a dwelling count. But what if the court had started with one of the drug counts or with the felon in possession count and said, you know what, there is no prejudice, and the balance of Barker factors say there is no speedy trial violation? Would my friends say that means the court has to stop and apply the ruling to the entire prosecution? No, they would say they need to keep going and look at the shooting into a dwelling count and determine that there actually was prejudice from the loss of a potential witness in this case. So what my friend is actually asking for is their own count-by-count approach that can only benefit the defendant. It's kind of a tails I win, head you lose kind of approach, where if you start with the count that has a speedy trial violation, you're supposed to stop and dismiss the entire case. But if you start with one that doesn't, you're supposed to keep going to see if there might be another count that has a violation and then dismiss everything. And that just doesn't make any logical sense. They turn to the language of the Sixth Amendment, which begins with in all criminal prosecutions, and say that that means that the unit of analysis and the basis of the remedy must also apply to the entire prosecution. As we point in our brief, no case adopts this formalistic view of speedy trial remedies, which makes sense because nothing in the text actually addresses remedies for the speedy trial right. But on top of that, the Sixth Amendment covers at least 6 or 7 other individual trial rights, from confrontation to proper venue. So if petitioner's text-based rule was correct, that would mean that every remedy for a Sixth Amendment violation must necessarily apply to the entire case. But we know that's not true. For violations, for example, of the vicinage clause, which deals with venue, of the notice clause, which talks about proper notice and indictments, the remedy is applied to address the violation. Now, of course, we know that the speedy trial right is different in terms of what the nature of the remedy actually is, in terms of dismissal with prejudice. Other rights do not have that remedy. But we're talking about the scope of the remedy, not the nature of the remedy.
Now, you said that the violation should not apply to the whole case. What's your best argument for that?
I think that comes directly from Barker, Your Honor. It says to determine if a violation occurred, you need to apply the 4 Barker factors. And the 4th factor, at least in cases like this one, only could have possibly been shown by prejudice to the defense. And that was shown according to the state trial court as to one count, but not another. So there's no basis in Barker to grant a remedy for where the test you're supposed to use to determine whether there is a right that has been violated says it has not been violated on this particular count.
Well, we get back to the fact that Strunk and Barker only involved the one issue.
Yes, and I think that does not hurt the state's position at all, especially under AEDPA. It just shows that there is no clearly established law suggesting you have to go further to dismiss counts where there is no violation. I want to talk very briefly, one more point on this before I turn to the second issue, which is the argument that my friend raises in their brief about this count-by-count approach leading to perverse or incoherent results. The exact opposite is true. Consider an example that's actually based on a real-world case of a murderer who broke into a house, assaulted and killed several women who lived there. He was charged with 8 counts of murder, 1 count of rape, and 1 count of breaking and entering. Now, imagine the alleged prejudice in that case is the loss of a witness who had left earlier that day and forgot to lock the door on her way out. Now, the loss of that testimony plausibly could prejudice a defense to the breaking and entering charge, at least under the common law, but it would have absolutely no bearing whatsoever on the murder or rape charges. Yet, if this court adopts petitioner's rule, it would require the trial court to dismiss every single charge in that case, including the rapes and murders. And there's no basis in the Supreme Court or in logic, again, for that approach. Again, the right is supposed to follow the remedy, or the remedy is supposed to follow the right, I should say. Very, very briefly on the second point, unless there's any questions on that, on the first argument. As we point out in our brief, the reasonableness of the state court's application of Barker to the felon in possession count is not included in the CO of A granted by the district court, and this court cannot address it. without at least first determining that the petitioner is entitled to extend the COA, and we submit that there is no basis to do so. This court time and again has said that disagreement with the state court's weighing of individual Barker factors is not grounds for reversal under AEDPA. That's the Russell case. And then in the Goodrum case, which we cite, the court said that even if a state court's conclusion regarding one or more of the factors was objectively unreasonable, it is not insufficient to grant relief because the court's ultimate decision is not objectively unreasonable beyond the possibility for fair-minded disagreement. So it would not be proper to expand the COA in this case. I only have a minute left, but I will try to hit the points from the second argument as quickly as I can. First, on the alleged prejudice from the loss of Edge's testimony, 3 quick points. One, they constantly refer to Edge's testimony. As in cases like Russell, the only reason we even know the petitioner knew Mr. Edge is purely based on his say-so. He said he can corroborate the testimony, but that never happened beyond offering an obituary, which we would submit does not corroborate testimony in any plausible way. On top of that, the prejudice is legally insufficient because petitioner says it would bolster a necessity defense. That defense, as the jury was instructed in instruction number 9 at ROA 775, requires petitioner to act immediately to relieve himself of the firearm he came into possession of, quote, without delay or detour. Under petitioner's own story, after he took possession of the rifle, he, quote, drank some whiskey, did some crystal meth, and waited around for 6 hours until the police happened to show up. So even under his own story, he would not be legally entitled to a necessity defense. And as we point out in our brief, it's also factually inconsistent. He says that the petitioner, that his proposed witness saw him go to and from his neighbor's house multiple times without a firearm. He now says on reply that he went twice, which means to and from, to and from. If his witness saw him go multiple times, that means he never saw him carrying a gun. He could not have taken it back in self-defense. I see I'm out of time. I have other things to mention, but if there's no further questions, I will. Thank you, Your Honor.
Thank you, Your Honors. I have 3 quick points. So first, I would just like to clarify that we're not seeking an extension of the Supreme Court's rule here. This is something we explained at page 8 of our reply brief. When we use the refusal to extend language that this court has continued to use post-White v. Woodall, what we're referring to there is that language as canoned by the Supreme Court, only in its permissible sense, consistent with AEDPA, in this Yarborough scenario where certain principles are so fundamental that when new factual permutations arise, the principle necessarily applies. So we're not by any means asking for an extension, we're asking for an application rather than an impermissible narrowing. Second, I'd like to address this sort of central fallacy that is at the heart of my friend's argument here, this notion that there's such thing as a speedy trial violation as to one count. That simply doesn't exist. The speedy trial right can only be violated, it's at the prosecution level. It's the right to be speedily brought to trial, not the right to a speedy count, the speedy disposition of a count. So when they concede that the remedy follows the right, they've given the case away. There are no tailored remedies permissible here. The right is at the prosecution level. The remedy is at the prosecution level. I'd also like to address the mischaracterization of the Mann opinion. That's the opinion that is cited at footnote 36 of Barker and makes clear that Barker had multi-count indictments expressly in mind when it laid down the rule as to remedy. So that case, the court did say that prejudice could have been fairly presumed. It said prejudice may be fairly presumed given the lengthy delay of this case. But then it expressly goes on to say the defendant has more than this generalist kind of inference to support his motion. So that court did not rely on presumed prejudice. It did look at particularized trial prejudice, and it conducted that analysis with respect to the prosecution as a whole, rather than count by count. That is the mode of analysis that the Supreme Court expressly endorsed in Barker. It shows that this rule applies to multi-count indictments. It applies here. It requires required dismissal of both count 1 and count 2. I'd like to also address the argument regarding the text here. Yes, in all criminal prosecutions applies. It's at the beginning of the Sixth Amendment, so it applies to all of the rights there, but you don't stop reading in all criminal prosecutions. The other rights are very different from the speedy trial right, and they have additional textual differences, and most importantly in substance, what the right protects is amenable to a remedy that is tailored to particular portions of a prosecution. So the right to counsel is the right to counsel in one's defense, and it can necessarily be violated many times in many different ways over the course of a prosecution. That lends itself to a tailored remedy. The Supreme Court has expressly said that that kind of remedy is not available for a speedy trial violation because this is a unique right. The court has time and again emphasized its uniqueness, and it's unique in the substance of what it protects. It's at the prosecution level. As my friend has conceded, the right remedy follows the right, so the remedy has to be a prosecution level remedy. My friend mentioned the second indictment in this case, the drug indictment. That in no way cuts against the rule that we're asking for to resolve this case. You need to go no further than to recognize that counts that have been grouped together by a prosecutor in a single indictment necessarily are part of the same prosecution. So count 1 and count 2 here, felon in possession and shooting into a dwelling, were part of the same prosecution, and so dismissal of that entire indictment is necessary. You don't need to address anything about the drug indictment, which that case has been retired to the files under Mississippi law, and that's not a live indictment at the moment. Thank you, Your Honors.
We have another question? Yes.
Would you briefly address the argument that we don't have jurisdiction to consider your second issue because it's not encompassed within the COA?
Yes, Your Honor. So I think the most straightforward way to address that issue, the reason there's no bar to jurisdiction there, is because this court can expand the COA. So we made the proper explicit request, page 41 of our brief, for an expansion, and we amply satisfy the standard for expansion of the COA, which is that any fair-minded or reasonable jurist could find the district court's disposition of the issue is debatable. We've amply satisfied that by showing that not only was it debatable, but it was in fact wrong. Thank you, Your Honors.
Thank you, Ms. Godina. Am I correct that you have been appointed in this case?
That's correct.
I would
Yes.
like to say thank you on behalf of the court for your able representation of Mr. Berryman.
Thank you very much.